Hey folks, we have major news. I have published a new article in the Harvard Journal of Law and Public Policy discussing some critical things about how we can cut back on some of these rogue lower court decisions that are antithetical not just to the text of the Second Amendment, but also to Supreme Court precedent governing our right to keep and bear arms. Let's get right into this geeky article you're going to want to read at the Harvard Journal of Law and Public Policy right now. Hey folks, I'm Mark Smith, host of the Four Box Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the winner of the top voice of the Second Amendment in America at the 2025 Gundies Awards out there in Las Vegas. Thank you all for your support. I hope to continue to earn your support in the year of our Lord 2025 as we continue forward to fight to restore our right to keep and bear arms all across this great nation. All right, folks, so we have an important new scholarly article out in the Harvard Journal of Law and Public Policy entitled The Third Rails of Second Amendment Jurisprudence. This is dealing with guidance on giving lower courts how to analyze historical precedents in a post-Bruen world. Now, I'm going to give you the issue that's popped up, and I'm going to tell you how I solve it with this article. As you know, in the U.S. Supreme Court's decision of Disarmed versus Bruen, which is really a paint-by-numbers approach to what the Supreme Court did in the Heller case in 2008. You know, we've talked a lot about this, you're quite familiar with this, that the way the methodology works when you interpret a Second Amendment case and try to figure out whether or not a modern-day gun control law violates the Second Amendment, you, of course, start with the text of the Second Amendment, the right of the people to keep and bear arms shall not be infringed, as defined by the United States Supreme Court in the Heller decision, which used definitions from dictionaries, from lexicographers of the time. In the 18th century, lexicographers like Samuel Johnson from England, Noah Webster from America, and others. And if you look at the definitions of the words of the Second Amendment, we basically know that the people consist of everyone associated with the United States, especially American citizens, of course. The right to keep refers to the right to possess. The right to bear means the right to carry guns and carry weapons, to carry arms in public for self-defense in cases of armed confrontation if that's needed. And we know basically from founding era dictionaries that the word to infringe, it means to hinder in some way, to restrict or hinder in some way, and that is an infringement. Now that's text, of course. Now if the text of the Second Amendment is implicated by a modern-day gun control law, such as a gun ban, a sensitive place law, a restriction, whatever it is, anything that hinders the ability to keep arms or the ability to carry arms in public, is an infringement at the textual level. You know what happens next. The burden shifts to the government because the presumption is that gun control law, to the extent it's inconsistent with the text of the Second Amendment, the presumption is that law is unconstitutional because it conflicts with the clear express language of a constitutional right in the Second Amendment. And you know the way it works from the government's point of view is they have to find a whole host, well-established, not hidden, set of historical analog laws going back to the founding of the country, to the founding of the Constitution and the adoption of the Second Amendment in 1791, during that time period in the founding, late 18th century, because obviously you want to look to the history at the time that the Second Amendment was adopted to try to understand what the scope of the right was. Now, when the burden shifts to the government to show this historical analog laws, and now listen carefully, this is where it gets a little geeky. We've been talking a lot about identifying appropriate historical analog laws, what is acceptable, what is not acceptable. We know it's pretty clear now that everyone agrees that the Department of Justice, even under Joe Biden, as well as the U.S. Supreme Court, that, for example, laws at the founding that were racist or anti-religious in some way, or would otherwise violate the Constitution today in some other way other than the Second Amendment, then those historical analog laws at the time of the founding have to be disregarded. They cannot serve as a historical analog law that the anti-gun movement in America can use to, in turn, justify a modern-day gun control law. Likewise, we also know that the time period that the historical laws have to be researched and reviewed has to be at the time of the founding, because if it gets too late in time, like at the late 19th century or in the 20th century, that tells us absolutely nothing about what the founders thought when they wrote the Second Amendment in 1791. I mean, what would someone, in 1950 be able to tell us about what the founders intended, other than by using historical documents and laws at the time of the founding? So at some point, though, the time period goes past and it's not relevant in any respect, except maybe as a confirmatory analytic, which we're not talking about right here and right now. So of course, we've talked about how the historical analog laws have to be from the right time period. They have to be well established. They have to be long standing. They can't be like a one-off. They can't be outliers. They have to be from actual states, the federal government. They can't be from, let's say, Western territories that were only around for a couple years. None of that's good enough. So again, but here's where I want to talk, what I want to talk about, and where I address an issue that keeps coming up in the lower courts to eviscerate our Second Amendment rights, and that is, once you have these historical analog laws, you then have to, of course, as the Supreme Court teaches in Bruen, you have to assess each of these historical analog laws, both why they were enacted and how they were enforced. So, for example, if a law that said there's a restriction on large quantities of black powder, gunpowder in Boston in the 18th century, because there was a fear about explosions and fire and burning down the town. The why that black powder restriction was enacted has nothing to do with, let's say, why a magazine restriction might be enacted today in the 21st century, where there's concern about crime control and gun violence and so on, right? So here you have an example where the why of a fire rule associated with black powder is much different than the why of a magazine rule today, one dealing with crime control and the 18th century rule dealing with, worry about fire prevention and fire, the burning down of the city via fire. So the whys wouldn't line up, as you couldn't use the 18th century fire law to justify the 21st century gun law. And also the hows have to line up. So the way it was enforced, the how it was enforced, is equally important, because not all laws are the same when it comes to that. So if the how it was enforced was there was a small tax, let's say hypothetically, that would not be sufficient to justify an outright permanent lifelong ban on the possession of firearms, because the how such a law was enforced at the time of the founding with, let's say, a small tax or fine, would not line up with the how a modern day gun control law, let's say 18 U.S.C. 922 G1, for example, dealing with felons in possession, would be enforced, which is a lifetime ban. So not only does the why have to line up with the historical analogs, and also the how they were enforced have to be lined up. Now, assuming, and this is where my article gets into, this article about third rails of Second Amendment jurisprudence, assuming, hypothetically, that the government defendants, in terms of trying to justify a modern-day gun control law, were able to come up with a long-standing set of historical analog laws going back to the founding, and said, we have these laws. We think these laws give rise to a principle, and here's the key. Those laws have to be assessed, but the how and the why, and assuming you still have laws left after you've done that initial cut, that initial filtering, what do you do with those historical analog laws? You have a basket of them. You have a bucket of these. You're looking at these. What is a judge to do? How does a judge analyze this? And this is where my article comes into play, which is they look at these laws and they are to derive or extract a principle, right? They are to extract or derive a principle of some sort. So, for example, you might come up with a principle that says that you have a series of laws that you say you cannot carry a dangerous and unusual weapon. So you could extract a principle from that says that the only way you could ban a gun is if it's dangerous and unusual. And by extension, if it's in common use by Americans for lawful purposes, it cannot be banned. So the principle to be derived from those laws banning the carrying of dangerous and unusual weapons would be, at least one principle would be, for example, as Heller teaches, if a weapon or an arm is in common use by Americans for lawful purposes, cannot be banned because it's not dangerous and unusual, because it's not unusual. So that would be an example of a principle derived. The in common use test was the constitutional principle derived from a series of laws and references in Blackstone to the banning of carrying of dangerous and unusual weapons. So what does my article have to do about all this stuff? So what my article does is to explain that there needs to be a series of tests. I call them third rails, because if you're dealing with like a railroad or a subway, let's say the third rail is the electrified rail, and if you touch the third rail, you electrocute yourself and likely die or seriously injured. So my argument here is there's a way that if judges derive a principle based on these historical analog laws, so you've already established the historical analog laws, you've then reviewed the historical analog laws, you've then derived certain proposed principles, there has to be another test to see if those principles that you have derived are okay. Are they valid in some way? And one of the key ways of doing this I am proposing in this article in the Harvard Journal of Law and Public Policy is to apply these third rails of Second Amendment jurisprudence as a test to see if the derived principles by the government and by a lower court are really valid. So how might this work? First of all, what are some of these principles, for example? Well, once you've derived a principle, which is what a court has to do, because, again, the process is they look at the historical analog laws, they conclude some are historical analog laws. If they find there are no historical analog laws dealing with the modern-day gun control that are analogous, then, of course, the text of the Second Amendment controls. The modern-day gun control law goes by the wayside. It's struck down as unconstitutional. But what if you do have a basket of historical analog laws that sort of pass the initial set of filters? What do you do with them? And the answer, of course, is you extract or derive a general principle from those examples. Now, if I can digress and give you an example how to think about this in a more common sense way. We know, for example, of the famous saying that says, all men are mortal. Socrates was a man, therefore Socrates is mortal or was mortal. The idea, though, is this. Where did the principle come from? The proposition come from? That proposition or principle that all men are mortal. Well, that principle or that concept came from studying examples. And the examples that were studied were all the men that have ever lived that we're aware of. And so far as we know, every man who's ever lived on earth as a human has died. Therefore, based on looking at those examples, we derive a principle or we derive a proposition that all men are mortal. It's what's known as a form of inductive reasoning in philosophy, for example. Now, by analogy, think about it the same way when you're dealing with these historical analog laws, trying to figure out whether these laws justify a restriction historically on your Second Amendment rights. The judges do the same thing. They look at these historical analog laws if they exist and if they're applicable. They look at these laws and they have to derive the principle. Again, they look at every man that's ever lived. They say they've always died, and the principle that is derived from that experience, that observation, is that all men are mortal. Likewise, these Second Amendment judges, these judges in Second Amendment cases, look at all these historical analog laws. Those are the examples, and they say, look at these examples. What is the principle or the proposition that we can derive or extract from these historical analog laws? And that's where the principles come from. And there's those principles, those constitutional tests that get applied to decide whether or not a modern-day gun control law violates the Second Amendment or not. So to offset or to address some of these attempts by the anti-gun movement and anti-gun judges to derive a principle so high that something like a principle that says, hey, these historical analog laws all were worried about public safety. Therefore, we're going to extract a principle that says that any law that's enacted that deals with guns that intends to or tries to protect Americans from the criminal acts of others is constitutional. That would be extracting or deriving a principle from historical analog laws that all deal with public safety at such a high level that it would eviscerate the right to keep and bear arms. And that is not allowed. So what are these third rails that I've come up with that I think lower court judges should start to apply to test the principles that are derived from these historical analog laws? Well, the first one is, of course, any principle that is derived cannot violate existing Supreme Court precedent. So if a lower court looks at a bunch of historical analog laws in, let's say, an arms ban case and derives a principle that says that, any gun can be banned for whatever reason, well, that proposed principle would violate the Supreme Court's decision in Heller and the principle that says if an arm is in common use, it cannot be banned. And that would be an example where the proposed principle by the anti-gunners and by the court would conflict with a Supreme Court precedent, and that means that proposed principle cannot fly and must be rejected. They have to go back to the drawing board to derive another principle if they can. The third rail that I've come up with is the focus has to be on the right holder, the law-abiding citizen, the ordinary citizen, and not on the criminal. In other words, the asserted principle by the government or by the court has to be based on concern of the conduct of law-abiding Americans and not on the criminal misuse of the guns. So if someone says that we have looked at historical analog laws and we've derived a principle that says that if an arm can be misused by criminals intent to do harm to others, you can ban or restrict that arm. That's verboten, because as this Heller Supreme Court case teaches, the focus is on how the right is exercised, not how someone can commit a crime or abuse the right. When we measure and define the scope of the First Amendment right to free speech, for example, we don't talk about the fact that some people can misuse the right to free speech by engaging in defamation, in libel, in slander, in fighting words, in obscenity, whatever it is. We laser focus on how people lawfully use the right to free speech to talk about politics or policy or the religious views or whatever. And again, likewise here, if the principle derived focuses on the conduct of criminals and not law-abiding, it's verboten and not allowed. That would be the second third rail that I've identified in this article. The third one, of course, is to the extent the principle is so high level or derived in such a way that would literally eviscerate the purpose of the Second Amendment to protect Americans against not just self-defense activities, but also against tyranny, invasion, criminality. Then again, if you basically are rendering neutered, or you're neutering Americans from being able to defend themselves against all forms of tyranny at all levels, then that would disregard the purpose of the Second Amendment. And that principle, if it disregards the purpose of the Second Amendment, would violate my third rail, and again would not be permitted, and that principle should not fly in court as a basis to take away our textual right to keep and bear arms. And the fourth concept is, if the principle derived would somehow convert our founding fathers into criminals. To give an example of this, in the Bruen case, which was a case involving whether or not we had a right to carry guns outside the home in public for self-defense, the question there was, that was the question, and a lot of people in the anti-gun side trying to make the case that at the time of America's founding, no one was allowed to carry guns, and if you carried a gun, that was a crime. But we know factually and historically that every single founding father, including the first 6 or 7 American presidents, going from George Washington all the way up through Andrew Jackson or so, every single one of them basically carried guns all the time in public for self-defense. They were always in and around guns in public, John Adams and the like. The point being that if you were to accept as a principle derived from history what the anti-gunners recommended or argued in Bruen, I should say, which is that the principle being that no one was allowed to carry guns in public at the time of the founding, that would have literally converted every founding father, including our first 6 presidents, into felons. And that clearly cannot be the case, that whatever the principle is, if you applied it to our founding fathers and their known conduct, if that converts them into criminals and to felons, that cannot fly either. That violates, again, the third rail that I articulate in this article in the Harvard Journal of Law and Public Policy. And again, the last sort of third rail I come up with here, and there may be more, there's many others you guys can come up with, let me know what you think, is that if you deny the rights of most Americans, the Second Amendment rights of most Americans, in other words, if you derive a principle that basically says that you could disarm 90% of Americans in some way, that obviously cannot fly, because we know the right of the people to keep and bear arms shall not be infringed means that the people includes all American citizens at a minimum. And if there's some principle derived from historical analog laws that would have the effect of disarming like 90% of the American public or a large percentage of the American public, that obviously cannot fly either. And again, that would violate one of the third rails that I articulate in this article. All right, so those are the 5 disqualifiers or third rails identified in my article. I'll put a link to it down below. And again, what this means is the process for analyzing a Second Amendment case where you don't already have a decision, I mean, like in the Heller case, you already have a rule dealing with arms ban cases, but if you have to analyze a Second Amendment question from first principles, let's say, then you have really, I see 6 steps, technically speaking. The first is you got to figure out whether or not the text is implicated by the conduct proposed. So is the text implicated by the gun control law today? The second is, if the answer is yes, the burden then shifts to the government to demonstrate the existence of a long-standing historical tradition of firearms regulation dating back to the founding. And the government has the burden to supply the court with a sufficient number of relevant time period, well-established historical analog laws. If they can't do it, then the government loses right then and there. Step 3, assuming they actually get to that point, that there are historical analog laws, then the district courts or the courts and the parties have to assess with respect to those laws that have been identified by the government, both the why of those laws and the how of those laws to see if they somehow line up with the modern day gun control law. That is step 3. Then you have step 4, which is from those remaining suitable analog laws. If you have any, there has to be a principle extracted, some sort of general proposition extracted from those remaining suitable analog laws. And then once you've derived that principle, whatever that might be, then you must make sure that that derived principle or that proposition, whatever you want to call it, does not violate any of the Second Amendment's third rails, which I've articulated 5 of them in this article, and I think you probably can articulate others. And last but not least, assuming a proposition gets through all of these things, the final step of the analysis, of course, is that the court must take that surviving principle and apply it to the case at hand, to the law at hand, to the plaintiff's proposed conduct or the plaintiff's past conduct, and determine whether or not under that principle those laws, those restrictions, those regulations violate the Second Amendment or not, or is there indeed some sort of historical tradition, regulation, exception to the text of the Second Amendment. And if there's any doubt, we know that the Second Amendment text prevails and the gun control law and the gun control restriction must fall, must fail. So there you have it, folks. Hope you check out my article in the Harvard Journal of Law and Public Policy. I'll put a link to it in the description below. I know it's a little bit of geeky. I know this is kind of high-end abstract stuff, but I think it's very valuable for the Second Amendment movement, and I think it'll probably get a lot of attention in courts and in scholarly pieces across the country, but I guess we'll see. Again, as we've talked about before, the history of the future has yet to be written. So there you have it, folks. Make sure you follow me on X at @4boxofdowner. Don't forget to subscribe both on YouTube and on Rumble to this channel. We're trying to get to 200,000 subscribers on YouTube, and I look forward to talking to all of you again very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.